We're just waiting for Mr. Heyman.
Let me unmute there. Your Honor, I think I'm on board now.
Mr. Heyman, your camera appears to be off as well. There we go.
Am I on now? There we go. Thank you.
You're on and we can hear you. We're ready to proceed.
Thank you, Your Honor. For the record, my name is Robert Heyman. I am the attorney for Kurt Lang, who was the appellant in this case. He was the plaintiff in the action before the trial court below. I believe that a chronology of events as alleged in the complaint will be instructive as far as having the court understand what this case is about. Basically involves a dispute over the beneficiaries of an IRA.
Mr. Hyman, we're pretty familiar with the facts. Okay. Can I ask you a question about Wayland here? Because what you're asking us to do is to go against, I think it's the case of Clavalox versus Bacatti, where we found that the trustee's incompetency was something that could be raised, that the incompetency of the trustee did not matter, so that someone could bring an action for inheritance expectancy prior to the death of the trustee or the testator. And so I guess my question is, as far as relying on Wayland, there we discussed that there's, obviously there's a tendency that I think this was struck down by the Florida Supreme Court in Shiners, but that a testator can do with his property what they want to do up until their death, and that we're going to allow that to happen. And so in Wayland, we stated that unless there's some, exceptional circumstance which allows for no adequate alternative remedy, then we're going to allow that. And I think that's what our court did in Carlson. And so what is the inadequate remedy that exists here with your facts?
Well, number one, Clavalox involved a will, I believe, and so it needed to go to probate. As far as Wayland, I think the distinction with Wayland is that the court at that time, the second DC, I think it was back in 1980, I believe, indicated that there was no evidence in the record what was up with either the testator or the grantee, or the grantor, that they may have been competent and they were still alive. And one of the major thrusts of our appeal is that while Ms. Lang is still physically alive, she had been found to be legally unable to make any changes to the beneficiaries of the IRA as they now stand. So, I mean, not to be crass, but legally she's as much as dead. And it's the
well, let me ask you that question. Is there any evidence, because I know she was seen by 3 doctors, is there any evidence that her mental capacity will change, or it's just going to further deteriorate?
She hasn't been seen by doctors since the determination back in April of 2018. I would suspect that that's not going to change. She's 87 years old. As the record reflects, she has multiple physical issues. So no, I don't believe that there's any evidence in the record that she's going to regain competency and be able to change beneficiaries, at least legally.
Okay, and our court in Clavalox, and I think I realized there was a will in that case, but I think there were also some. Is that the case where there were also some bank accounts? I don't know that the court addressed the joint bank accounts in that case, but the opinion seemed to direct itself to the will and the trust going to probate. But will we have to recede from Clavalox?
I don't believe so, Your Honor. Once again, I think that because there was a will, I look at that as I put that down as the distinguishing fact in Clavalo. There was a will and a trust. The will needed to go to probate, even though the testator was incompetent. I mean, at that time, this court backed off on letting her proceed with an intentional interference with a expectancy base, and they would not accept the Harmon case that was in Maine, that at that time was described as the only place in America where this was being accepted. So I think those cases both are distinguished, and I put that throughout my brief,
Well,
that,
let me ask you this, because there has been, you know, a tendency for these types of torts to defer them till after, you know, the testator, or trustee or, family member, whoever passes, right? And so what's the harm? What prejudice, is there to your client?
well, let me quote from Harmon, and I also put in my brief, there was a article from Res Gestae. The harm is my client is, first of all, it's not a probate matter. It does not belong in probate. But number two, from a practical standpoint, Marie Lang is still alive. And quite frankly, it would be nice to be able to take her deposition to see what her actual intention was. We wait till she dies, and then we don't have that evidence. I have filed
Okay,
a.
so has any proceedings been brought to try to take her deposition? I mean, because you're telling me that 2018, you know, some years ago, 6 years ago now, was when she was last seen by the doctors.
As a matter of fact, that has occurred, Your Honor. I filed a motion to perpetuate her testimony pending appeal. As soon as I filed a motion, that has been brought before the trial court.
That
on one
was
occasion.
after the appeal, not before.
Correct, after the appeal. Before, I mean, I filed the lawsuit, I believe, in August of 22. But I have filed that with the court. The first motion was denied. Quite frankly, I don't believe that there was sufficient evidence on the record for the court to make that determination. I filed a subsequent motion to perpetuate her testimony, which will be set for hearing. The bottom line is the court needs to make a factual finding. And as far as the witness's ability to testify, as the court knows, I mean, people who have been to insane asylums have been determined to be able to testify. I tried a case back in probably 20 years ago, a murder case where the witness had been beaten with a ball-peen hammer and had some physical issues and neurological too. The judge permitted him to testify. So yes,
if you're okay, I mean, I know this is all, you're talking about the testimony and seeking the testimony. This is all after the fact. But let me ask you this question. If you were able to perpetuate her deposition testimony prior to her death, there wouldn't be any argument for any sort of inadequate remedy, because that's what is that the crux of what the inadequate remedy is?
If I could do that, I'd feel a lot better about representing Mr. Lang. I agree with you, Your Honor, but the problem is, to date, I believe that the defendants are also Mrs. Lang's sons, that they have opposed that. I know the guardian has opposed that. If they would agree to that, we might be in a different posture, but I get my suspicion is that they will never agree to let her mother testify. I know I only have a few questions to ask, but don't we all want to know what went on February 18th, 2018, when that all of a sudden the beneficiaries were changed from my client singularly to the three defendants in the case below, and also her account was transferred to Connecticut, which was apparently down the street from one of the defendant brothers.
Mr. Heyman, I want to ask a couple of questions. The most important one first is, are you reserving any time for rebuttal?
Thank you, Your Honor. I'm glad you brought that up. Could I reserve 5 minutes?
Okay, then my second question, which goes to the substance of this, and it's a follow-up to what Judge Smith asked. Waylon involved a trust that apparently was assumed to be revocable. However, it also involved estate documents that had been prepared. So it seemed like there was at least a direct correlation between the issues that were presented and the need to go through probate because of the other estate documents. We don't seem to have that here. Here it's just the IRA, which had a change in the designated beneficiary. So that's all the lead up to my question. The other side argued, and I think you agreed in your reply brief, that there could be a collateral proceeding to probate to allow these issues to be developed. What would that collateral proceeding look like? I mean, are we all assuming that is a possibility, or is that a definite, yes, there can be a collateral proceeding?
Well, I know under the rules, for the purposes of judicial economy, cases can be consolidated that address the same issues. My problem is this case may never go to probate, quite frankly, because the other assets that are held by Marie Lang, she has two trusts, one in her name and one in her deceased husband's name, and she has this IRA. my understanding is, and as at least as far as the record is concerned, she has no assets that will be required to go to probate.
But, and what I'm trying to figure out is anybody who has an interest can initiate a probate. In theory, your client could initiate a probate proceeding. But we have an asset that is typically unrelated to probate. And so that, and this question will be equally directed to Mr. Green, because I'm trying to figure out whether or not, in fact, a probate proceeding is required to resolve this issue, or whether this meets the exceptional circumstance of what appears to be an incompetent individual who created an IRA with a designated beneficiary. The beneficiary would change or was changed. So I'm still trying to get a handle on that. And I don't think your questions and answers with Judge Smith didn't really seem to me to hit the nail on the head as far as what does that proceeding look like?
Assuming that a probate cause was filed, I'm assuming by someone, perhaps even my client, he would file a lawsuit for interference with an expectancy. I believe he would be able to do that. But quite frankly, Judge, like I said, I don't see that happening. I don't certainly see the defendants, based on at least their alleged behavior here, wanting to go to probate to determine who the beneficiaries are. And like I said, all of the assets that we know about are not subject to probate. So why should my client have to proceed to a probate proceeding over an issue or the IRA that isn't subject to probate? I don't understand why he would not be able to proceed right away, so long as, I mean, it's based on fraud. And fraud is complete when the last act completed that consists of the fraud is done. That was done in February of 2018. Of course, the standard is knew or should have known about the fraud. As I indicated in the record, my client really learned about this fraud approximately 2021 during a mediation when the defendants tried to sneak some language in that really was unrelated to that mediation. So quite frankly, and the other issue is statute of limitations. Fraud is 4 years. It may go, say it's appropriate that he learned of the fraud in early 2021. Ms. Lang could live who knows how long. And I would expect that if we file this in 2028, that the defense would be that, well, sorry, the statute of limitations has run. They put in their brief glibly that there should be no issue with the statute of limitations, but I disagree. I would expect them not to be able to be willing to stipulate that the statute of limitations wouldn't run until Ms.
The statute of limitations run when the last act occurs, and the last act would be damages, which sort of brings me to my question. There are 4 things you have to prove in order to prove an intentional interference with an expectancy. 1, the existence of an expectancy. 2, the intentional interference with the expectancy through tortious conduct, causation, and damages. Damages is where I have a problem, because an expectancy is not an asset. You know, I don't own an expectancy. I can't pledge an expectancy. I can't spend an expectancy. Not only that, an expectancy can change the day after it's made, either, you know, through a competent person or that person's representative. On top of that, pots of money like this for elderly people who have healthcare needs, that's a moving target also. How much is this pot of money going to be at any given point in time? I mean, the healthcare industry can suck down $1 million so fast and make your head spin. You know, what's to say there's going to be anything left at the time? So I have a real problem with the damages aspect here. How has your client been damaged? He doesn't own it. I mean, it could easily be legally changed tomorrow or the next day or 4 or 5 times by you know, an attorney in fact. And will any of it be left at the end of her life? How do you quantify the damages here?
Well, I have a few responses. Number one, I don't know how the beneficiaries could change to this IRA. I don't know how a court would somehow authorize some type of a change that was done by the actual grantor who is now incompetent. I just don't understand any reasons or circumstances under which that could occur. Number two, as far as speculative, I agree. There's a lot of case law out there that was cited by the defense where it's a will, where the testator is still living. That was the case in Whalen versus Prosser, where that there still could be changes because the person that had issued that whatever document it is was still around. It could have changed their mind. That can't happen. Our argument is the damages are set in this. Well, let's put it this way: the issue of damages is set. The amount of damages is not. I would think it'd be awful public policy if someone was able to do this sort of behavior, which, quite frankly, I look at view as quasi-criminal, and they hope to God that the person that they misappropriated the funds through spends all the money before they end up having to face any responsibility. So I think since the damages are set because the beneficiaries cannot be changed, I think they exist. The amount is going to be determined when she passes away. I certainly agree with that, but I think it's
The other issue in this case, of course, is your client is not does not have clean hands. It's been alleged that he misappropriated about $1 million from his mother all by himself. And I can see a rational trier of fact looking at this and saying it's about even now.
Completely irrelevant, Your Honor. I think it's, quite frankly, I don't see how it was almost argued outside the record. If the court needs to know, that case was resolved in my client's favor, where he received $150,000 from the estate.
Mr. Heyman, we will not consider any of that. I know the issue was pointed out in the briefing, but we don't need to hear any more details about that.
Okay, I understand, Your Honor. That's why I only brought it up because it was in the question.
So let me let you just to get back to the question Judge Morris asked. Go ahead and respond to the extent you have a response. Otherwise, you're at your 5 minutes of rebuttal.
Okay, I think I appreciate the question, and I think there are a number of cases before the court that were decided against people in my client's situation where there was a live and competent testator or the grantor in a trust to be able to make changes. But the fact is, they're locked in. It's locked into these three beneficiaries who, in our viewpoint, as set out in our complaint, did it through devious and basically unlawful means. It's going to be the amount that's going to be the question, not the fact that there are damages. And as I pointed out, I think it would be awful public policy if the people could conduct this type of behavior, and then hopefully at the back end, when the person passes away, there's no money left, so there's no foul. And I'll reserve my time now.
Very good.
Thank you, Your Honor.
Thank you, Mr. Green.
Thank you, Your Honor. May it please the court, my name is Billy Green. I represent two of the three appellees, Kyle Lang and Chris Lang. I'll start off thanking the court for the time, along with Mr. Heyman, who is always very professional and great to work with, as he always is in every case. For purposes of my rebuttal, I'm mostly relying on the case law provided within the brief, which I know we've already discussed a little bit in the opening remarks. There's really no evidence to consider in this case. There was no discovery conducted. This case was dismissed at inception. So this really is just purely a de novo review. We're simply asking that the court affirm the lower court's decision, as it was consistent with the long-standing, well-established case law in Florida.
Let's jump right to that, Mr. Green, because each of the cases that are cited have some distinguishing factors to them. None of them is on all fours. And so I do think one of the questions that is important to get a handle on, which has to do with what is the available remedy in probate for what is traditionally absolutely a non-probate asset. And the reason I ask this question is, you said there's an available remedy in the brief, but you didn't really cite any authority or explain what that is. Mr. Heyman, in his reply brief, seemed to concede, yeah, there might be another avenue through the probate court. How do we get to the probate court for a non-probate asset in this kind of situation?
Well, Your Honor, and a great question. It's really the testing of when you determine whether there is an adequate remedy. You cannot determine whether there's an adequate remedy of probate until death. There's already been some conversation about this panel amongst the various things that can happen to an asset while a person is alive. Minimum distributions. A guardian could apply to disclaim the interest for Medicaid.
Clearly, the money could be gone. I mean, there could be millions of dollars in healthcare expenses.
To your point, if the account kept its designation as a retirement account with a payable on death beneficiary, and at that point Ms. Lang passed away, there would be no adequate remedy. So mixture with the death of the testator, with there being no adequate remedy, you would be able to file a civil complaint for tortious interference at that time.
So your
Mr.
contention is based on what? That you could, because now, let's say she lives till 2028, I think Mr. Heyman said. Wouldn't there be at least some ability currently outside of probate to do what the second count asked for, which is damages, or in the alternative, a constructive trust? And again, the reason I'm bringing that up is the minute she dies, in theory, your clients can race to the bank and say, give me every penny that's in that account. We're the designated beneficiaries, cut the check. And so he would be left now with trying to go after them on a suit to recover the damages, when the basis of his suit is they shouldn't be able to touch the money. I'm the designated beneficiary.
And I don't disagree that that's an issue, these type of cases. It's something as probate trust attorneys we deal with all the time with non-probate assets. But I think that overlooks the very heart of some of the public policy considerations that caused this court to make its findings in Wayland. Again, one of the requirements from this court in Wayland is exhausting probate remedies, and you cannot test whether those remedies have been exhausted until time of death, because that's when you determine whether an asset is titled individually through transfers or whether it's still in an IRA that would be outside of probate.
But Wayland involved documents that clearly invoked probate proceedings in the future. Because there was some wills, I don't remember if it was wills, trusts, pour over trusts, but there were estate documents that potentially would defeat the IRA. We don't have that here, or at least we don't know that we have that here.
Well, and I think Wayland and its progeny focus less on the title of the asset, how it is. It's more on the cause of action. When I read Wayland, it speaks specifically to the tortious interference cause of action that can apply to any asset, whether a trust, will, Totten trust, IRA. I mean, it applies across the board. It really where Wayland, where it speaks to me and what we all look at in these cases is the problems in having a pre-suit contest. You know, one is the revocability of it. And I know Mr. Heyman mentioned that she's been declared incompetent. No discussion whatsoever that isn't an issue. She's been found partially incompetent. But if she was to go into the bank today and change the designation, it's not per se invalid. It's presumed invalid. The court, for purposes of legal consideration, have to at least contend that there's a chance of restoration. I agree, unlikely. And it's the court's finding that there isn't a vested right. It is tortious interference with an expectancy. An expectancy in the very title of the cause of action, it claims it's not a vested right. So, and again, that is one of the multiple tests in Wayland. The other is the exhaustion of the probate remedies, which I know your question is centered at. And again, not trying to circumvent the question, it's just by the very nature of quantifying whether you have a probate remedy, you have to have probate. I mean, there's just no way to test what is in probate, what's not probate, until there is an irrevocable nature of the estate, which does not happen until death. Again,
But it also does not. But it also does not happen with an IRA.
If the IRA was as it sits today, then it would be a non-probate asset. But again, Ms. Lang, even being incompetent, has a legal guardian. That legal guardian could move to transfer the funds for purposes of paying assisted living, could move to disclaim it, could use it to pay guardian fees. There's a myriad of different applications.
Mr. Green, in Carlson, we allowed this based on some exceptional circumstances, which we found to be the statute of limitations. Is there an inadequate remedy here where Ms. Lang can be deposed now, as well as other witnesses? Because we don't know how long she's going to live. And then you have the passage of time with depositions, memories fade. And so, I mean, isn't that enough as far as exceptional circumstances to allow the suit to proceed now?
So I'll try to answer both of those questions. And yes, Carlton was a case where this court found exceptional circumstances basically because the alleged tortfeasor in that case died. So you were subject to the 2-year statute of limitations on making a probate claim. This court has the ability to carve out additional exceptional circumstances. But to your point about the depositions and just piggybacking some of Mr. Heyman's comments, that was brought up to the court. This court, where we're having the appeal today, did not rule. They deferred to the guardianship court, a different judge, Judge Campbell. Judge Campbell denied that request in the guardianship court. I'd note, just for clarity, again, I don't believe there's any findings related to that deposition request in the final judgment being appealed today, but just for clarity of the court, that's what they found. It was deferred to Judge Campbell and the guardianship. Judge Campbell denied it without prejudice. I believe that will be pursued again. To answer your question about the remedies, again, it's not a perfect world. There are limitations in these during life contests. I mean, the most important witness in these cases tends to be the testator, but this court through Wayland made a public policy decision to protect parents from that type of dispute, realizing all the additional issues as to damages, how do you quantify them, as the revocability, and then as to this court's, Judge Altenberg made some really eloquent findings in the opening of Wayland. And again, just a comment there, we fear this small step for the Waylands could be a giant leap towards unwarranted interference into the private and personal decisions of living testators. This court made a decision that children have the rights after death. The remedy is to file the tortious interference claim after death like we do in every single inheritance contest that's not probate. It can be a trust asset, can be a TOD asset, anything outside of the probate, that's how we handle it. And there are shortcomings. But again, this court has every right to make an exception. But I believe this exception was argued in the Biscotti case, and this court, for the same reason, the public policy reasons cited in Wayland, made the decision that that did not meet the extraordinary exception of what was found in Carlton because of statute of limitations. Not to mention, speaking of statute of limitations, if there is an exception for an incompetent testator and we allow this pre-death action, we've created a tolling statute of limitations for every child who doesn't contest a will change or a TOD change during life. I think the court made a strict line here. And again, to Mr. Heyman's comment, there's no argument. Statute of limitations tolls until the death of the parent. So he has every right to claim a civil action for tortious interference if there were not probate remedies at the time of death.
So I may have missed a slight piece of what you said, but you're essentially conceding that at this point in time, the statute of limitations has not begun to run.
For tortious interference, that's correct.
Okay. And conversion?
Conversion, I think, is a little bit more difficult. I think the plenary guardian at this point would be standing in the shoes of the ward and would have the right to pursue that. I don't know the answer to that one. I think that might be more of an issue, but with conversion, again, conversion implies ownership. I think that goes to the lack of standing issue that a expectant beneficiary has no right to claim conversion when a prerequisite of conversion is actually owning the asset that's been converted.
You can proceed.
Thank you, Your Honors. Well, again, Your Honors, I think we've met most of the arguments I planned on speaking towards related to this. I'm really depending on Wayland and his progeny. It's been upheld in Florida for several years. And frankly, as a practitioner, it's good case law. It limits the very thing that Judge Altenberg and this panel foresaw. If we allow pre-death actions, that these courts will be flooded with siblings, children, step-parents suing each other during the life of the testator. And again, Wayland is not just about competency, whether something is subject to change or not. As we mentioned, there's no vested right in expectance. Designations can be amended, might be presumed invalid, but they can be amended. Again, we spoke to the inability to calculate damages. Even in the exception, the case where this found in Carlton, which I agree with, there was no choice. They call it a contingent claim. I don't know how the lower court ultimately dealt with that, but they made a preservation of the claim simply because if that action was not filed within 2 years, it was forever extinguished because of the death of the tortfeasor. In this case, my clients are being accused of wrongdoing, but they're alive. If something happens to their mother, Mr. Lang, the appellant Mr. Lang, has every right to bring suit at that time. And again, just speaking to, I could quote 6 or 7 different passages from Wayland and talking about the reasons that this is denied. But again, I spoke to a little bit, it's just the increase of litigation that will take place would be paramount. And again, I think we would be creating as a court and as a system here, a statute of limitations issue that doesn't otherwise exist now. If we allow a carve out simply for the fact that there is somebody who has capacity concerns, almost every inheritance dispute has a claim of some level of incapacity or diminished capacity at the time the document was done. If we carve out an exception for this case, which I believe has really already been dealt with by Biscotti, then we are inviting a scenario where the statute of limitations no longer tolls until death. It tolls on the act. And at that point, children, step-parents, spouses are going to be forced to bring suit to protect their interests during the life of the loved one, which is, I think, the entire purpose of what we were trying to avoid in Wayland. Thank you, Your Honors. I don't have any additional comments, but happy to answer any questions that you might have.
I keep thinking about, would there be a mechanism available at this time, whether through this lawsuit or an amended lawsuit, to prevent your clients from, upon her death, immediately racing to the bank to taking the assets?
I don't believe there's anything absent the guardian putting some type of letter, or any party writing a letter to the bank that the assets are in question. You know, as a practitioner, when we deal with these issues, and it's very common, we immediately send a letter at date of death to the custodian of the funds, letting them know it's in dispute. That usually has the net effect of freezing it. But no, to answer your question, that there's no legal remedy that I know other than practical devices that we use as practitioners.
Very good. Unless there are other questions, then we will turn back to Mr. Heyman.
Thank you, Your Honor.
Thank you.
Just a few notes. I mean, quite frankly, I'm not asking the court to cut out any exception whatsoever. I think that counsel's argument is really discussing apples and oranges. An IRA is not a probate asset, does not need to be the subject of probate litigation. And the issue of it, whether or not the existence of his claim is too speculative, I think it's nailed down by the fact that a judge has ruled that she is financially incapable of making her own decisions. And while the guardian can spend money, can direct it in into investment areas or whatever, she can't change the beneficiaries. And that's the real issue here. Beneficiaries are locked in. This was $1 million IRA. I know that they potentially there could be nothing left at the end, but the fact of the matter is the beneficiaries are who they are. And the wrong has been done. It's just a question of the amount of damages, not the fact that there are damages. The ruling by the trial court just doesn't fit the facts. I mean, from the record, her ruling was that it does appear that this falls within the category of Wayland and all children's, and it does seem to be an inheritance dispute, even though it's not a dispute over a will or trust. With all due respect, I don't understand what she's trying to say there. It's either an inheritance dispute involving a will, or anything, whatever other property could be subject to an inheritance issue, but it's not. And it doesn't have anything to do with All Children's. All Children's was a case where All Children's Hospital basically tried to get a second bite of the apple. They agreed to let the estate of the beneficiary go through probate. Then they came back and filed suit to say that some of the assets had been stolen by a third party. So I just don't see where that applies. I don't see where Wayland applies. Once again, Wayland, I know, has been quoted highly by the defense in this case, by the appellee, and I respect that. The distinctions are that there was apparently a competent grantor in Wayland that which could have had the effect of changing the amounts of the beneficiaries of whatever I think it was a will and a trust in Wayland. So, I mean, I still hear the defense saying, although at the lower court, they argued that it was a 100% a probate matter. In their briefs, they acknowledged that the IRA is not a probate matter, but we could perhaps piggyback it onto a probate cause of action. Why do we have to do that? I think the public policy should be you probate what's in probate, and if it's not a probate asset, you can do what you want with it. As far as filing, once again, who's going to file a probate action here? Mr. Green's clients, I really suspect they won't. Just for the very issue that you bring up, Your Honor, that they have whatever money is left in that IRA when she passes away, goes to them directly without any need for the court to take any action. So I think this is a case where the line has to be drawn between a probate asset that it needs to go to probate and one that's out of probate and does not have to. I mean, I quoted the Martin case where as usual, it's the second wife that had the will changed. There was a will and there was an inter vivos trust. The will needed to go to probate. The court ruled that the inter vivos trust did not. If that consequence happens in this case, it would be catastrophic for my client, quite frankly. And should he be forced to file a probate action where really one is not necessary, merely to keep somehow comply with Wayland, which I just don't think applies. I think the court needs to draw a bright line here. I think the trial court below made a mistake. It's not an inheritance issue. I haven't heard counsel even say that it was. And I think from a public policy standpoint, he should be able to proceed now. From a practical standpoint, he should be able to, if this cause is reinstated, the next witness I depose is going to be Mrs. Lang, because we all want cases to be decided on the merits, and that's all my client is asking for. And he should be able to do it sooner rather than later. And I thank you for your time.
Very good. Both counsel really well argued, well briefed. We appreciate the help on this. You both did a really nice job for us. So thank you very much for that. Mr. Green, Mr. Heyman, thank you again. And we are adjourned. That's the last case in the docket. We're done. So thank you all.
Thank you, Your Honors. Have a great